Hello, my name is Senior Judicial Registrar Anne-Marie Rice. I'm also the Executive Director of National Registrar Operations and Practice at the Federal Circuit and Family Court of Australia Division 1 and the Federal Circuit and Family Court of Australia Division 2. I come to you from Meanjin, Brisbane, home of the Turrbal and Yagara people, and I pay my respects to the elders of all of the lands on which we are gathered. I'm very pleased to have the opportunity to speak to you about the Court's approach to priority property pool cases. Since the 1st of March 2020, the Adelaide, Brisbane, Parramatta and Melbourne registries of the Federal Circuit and Family Court of Australia Division 2 have run the highly successful priority property pool under $500,000 pilot, the PPP 500. In this pilot, cases with asset pools of under $500,000, including superannuation, were carefully case managed by registrars to ensure that they were able to proceed quickly to dispute resolution conferences, or, if necessary, to timely and streamlined trials. Case management in financial matters involving modest pools has focused on addressing the potential consequences of delay, non-compliance, and disproportionate legal costs. The pilot has been positively evaluated by the Australian Institute of Family Studies, which found that the model was a highly efficient way to assist parties with modest pools resolve financial matters in a timely way. Over the period of the pilot, approximately 78% of cases were managed and finalised by registrars within 5 months of filing, and this in turn freed up considerable judicial resources. The evaluation also found that the model yielded favourable social returns on investment and social value outcomes for the parties, including improvements in their financial well-being. And significantly, the evaluation noted that vulnerable parties, including those with allegations or evidence of family violence, were able to access quick settlement outcomes or pathways to judicial determination where that was required. As a result of the sustained success of this focused, cost-effective case management model, the courts have received funding from the Commonwealth Government to expand the initiative to all filing registries nationally. The criteria for inclusion as a PPP case has also been expanded to afford greater numbers of parties access to this case management model. From the 30th of October 2023, a matter will be eligible to be designated as a priority property pools case, a PPP case, where the application seeks only financial relief. In other words, where the orders sought only involve property adjustment or spouse maintenance, and where the asset pool has a total value of up to $550,000 excluding superannuation, or where the asset pool has a greater value than $550,000 excluding super, but the court, in its discretion, designates the matter as a PPP case, having regard to relevant features including family violence, limited complexity, or the risk of disproportionate costs or delay. Practitioners are expected to be familiar with this criteria and to discuss it with parties prior to preparing material for filing. Where the applicant identifies that the pool is less than $550,000 excluding superannuation, only the following documents need to be filed: an application, a genuine steps certificate, and the PPP case financial summary in the prescribed form. A new form will be in place from the 30th of October 2023, but there will be a grace period for use of the previous form until the end of the 2023 calendar year. In circumstances where the applicant has identified that the pool meets the financial threshold to be a PPP case, there's no requirement to file an affidavit or a financial statement or questionnaire as otherwise required under the family law rules. However, matters in which those documents are filed will still be considered for designation as a PPP case. This PowerPoint provides an illustration of how PPP cases will be identified and managed, and it can be found on the court's website. At the time of filing, all applicants will be guided via the Commonwealth Court's portal to consider whether or not the case involves a financial-only application. If it does not, if, for example, financial orders are sought along with orders in relation to parenting arrangements, then the matter will not be eligible to be classified as a PPP case, and the usual initiating material is required to be filed. In those circumstances, the matter will proceed in the standard case management pathway, where there remains a focus on facilitating safe and productive dispute resolution. If the matter does involve financial relief only, and if the applicant identifies that there is a total asset pool of under $550,000 excluding superannuation, the Commonwealth Courts portal will guide the applicant to commence the proceedings by filing only the application, genuine step certificate and PPP case financial summary. If the pool has a value of over $550,000 excluding superannuation, then the applicant must file the initiating material required by the rules, and the court retains the capacity to designate the matter as a PPP case. Regardless of what material is filed, judicial registrars will assess all financial applications within 2 business days of filing, and the matter will either be designated as a PPP case at the court's discretion or confirmed as being appropriate for PPP designation based on the limited material filed by the applicant. Where the matter meets the PPP cases criteria, the judicial registrar will commence the focused case management process immediately. And this will include making chambers orders in anticipation of the first court event. Those orders will address issues including service of the material on the respondent, the material the respondent is to be filed and the date by which that is to occur, disclosure that may be required, including encouraging the parties to engage in direct discussions where it's safe to do so, the approach to be taken in relation to potential valuations and how the costs associated with that are to be met, the filing of any family violence protection orders or applications, and an exploration of the dispute resolution options, including considerations regarding legal aid conferences. Compliance with those orders is expected, and it will be closely monitored by the judicial registrars. PPP cases will continue to be proactively managed by the judicial registrar so that issues can be narrowed and the matter can proceed to productive and safe dispute resolution conferences as soon as possible. In unusual circumstances, the matter may have a second mention before a judicial registrar before being listed for a dispute resolution conference. Conciliation conferences with judicial registrars will be prioritised for PPP cases, and eligible parties will also be referred to legal aid conferences. Private mediation or arbitration will remain available to parties who are in a position to meet the costs associated with those processes. The considered approach to case management will allow registrars to quickly identify and address any issues in relation to non-compliance, lack of disclosure, or failure to meaningfully negotiate, including by making costs orders or referring the matter to a judge. This will actively reduce the opportunity for non-compliant parties to engage in systems abuse or to otherwise frustrate the finalisation of matters where costs and delays can be ill afforded. Where matters cannot be resolved at dispute resolution, the registrar will discuss other means of finalising issues in dispute in a timely and cost-effective way. This will include speaking with the parties about the benefits of arbitration or a short-form final hearing. Where a matter is not designated as a PPP case, it will be case managed consistently with the central practice direction and will proceed to a first return date before a judicial registrar at the earliest opportunity. The new practice direction and the PPP financial summary will be available on the court's website from 30 October 2023. You'll also find on the website brochures about PPP case management and some answers to frequently asked questions. The courts look forward to working with parties and practitioners to reach timely outcomes in priority property pool cases. Thank you for your time and attention.